me back and being a part of this. Thank you, Lisa, for pointing out this is a new contract. I think we talked about that the last time where we said this time of the year there will be a revision. So great catch. And if you could, Lisa, just spend a couple of minutes. I know that there hasn't been much change, but real quick, just maybe mention the change that you did see that you got from HBR or whoever sends us out. Lisa, you there? Did I mess something up?
It's me. I didn't unmute myself and I'm chattering away. So I'm going to share my screen and I'm going to pull the document up. Did everybody see that or did I mess that up?
All we saw was your files. We didn't see the document. Okay. There. Yeah.
So I'm going to just walk you through quickly what's changed in this that I've seen so far. And this, what I sent out to you earlier today, is the annotated version. So anytime a board of realtors or an MLS change forms, they give you typically, you go through the process and they'll put a version out for feedback from the leadership and the constituency and say, this is what we're thinking of changing. It's just a draft. Does anybody have feedback? And when you get those, you do want to, pitch in your thoughts on this. And certainly if you see issues that happen in transactions and cause problems, bring that to the Hawaii Association of Realtors and to your representatives as well. So once the form comes out, they typically produce the new clean form that goes into zip forms immediately. And they have an annotated version, which shows you the markups, the changes. So I'm going to show you that in 1 second. The other question that came up this morning is, does this automatically show up in your zip forms? As long as you're connected live to zip forms, which you all should be all the time anyway, then when you open a new transaction or you pull in a new purchase contract, it will be this version. And you'll know that because it says revised 1021 and released 1221. And so you all got the email yesterday. And the only ones, it will not go back and change contracts that are already in your files. And so far, we believe in what we see is that all of the templated versions that were the office level templates will float through this. I don't believe if you set up your own personal templates that they will. Okay, so.
Question on that, Lisa, real quick. So I wrote an offer on, today is what, Thursday. I wrote an offer on Saturday and it's been in my inbox, and then I forwarded it over to a broker on Tuesday. And I'm waiting for a response, and let's say I get it approved, then it's today, but it's on the old form, but it's been signed off by the broker.
It's no problem.
Is it okay to use?
Absolutely. The only time we need to watch out for these is if there's a legal change in the code or if there's been some kind of problematic liability issue that the board fixed because of those problems. But this is absolutely non-substantial. So you'll notice everything so far looks pretty similar. I see some little, cleaning up and organization, and the types fonts are a little bit different. But when it gets to M1, see, like this looks a little bit different.
Yeah.
Verification of class. It's lined up a little bit.
Yeah, the format. Yeah.
Even this, the formatting's cleaned up a little bit. Just a little graphic difference, right? Okay, so M1 is the only change that I found.
And it's actually underlined in the copy that I have that Carrie gave me.
Yeah, so it's red and underlined. So they added this word. So it used to say in accordance with Hawaii Revised Statutes 508D, they put in chapter. So clearly somebody sat in Word and said, you guys should put in chapter because 508D is chapter. It's not the statute. So that got added, and you'll see that the formatting changed in section B. So it's now dot points. And it already says seller shall provide buyer with the following documents to the extent that they exist and are obtainable. And the changes, we used to have a line under each of these sides. And on this left side, it said, including or other, and be specific. And if you work with me as your BIC, I'll say, stop doing that if you write in something like any that apply, because that's not specific. So specific would have been something like, covenants inspection. That would be specific. Now, so now it just has one line that says others be specific, be specific. So we always want to be specific. So you don't need to say any that apply. Just be specific.
Perfect.
Everything else is the same. A
Perfect.
little bit fewer lines on Q, I think.
And it's still 14 pages.
Yep. So I would stop sharing this and turn it all over to you.
Okay, thank you. And welcome back, everybody. Okay, so we'll just dive into it. I've got to leave here on time or a little early if possible. So just setting expectations there. I don't think is anyone here new? The names mostly look familiar.
I'm new. I missed the first two, but I watched the videos. I had to work during that time.
Okay, no problem, Tori. Thanks for letting me know. So you know the process, right? We're going to take turns.
The other videos were awesome. Thank you.
Okay, excellent, excellent. Okay, so we'll start with I-6. Let's just dive right into it. So we'll all take turns reading. I'll start. Okay, so this will be under Section I. Section I is mandatory seller disclosures in real estate transactions. So I-6, general disclosures. So paragraphs I-6A through I-6I describe general issues which could affect the property. Buyer should make appropriate inquiry regarding these issues as part of buyer's inspection right under paragraph J1. A, governmental and private restriction disclosure. The property is subject to all applicable federal, state, and county laws, statutes, regulations, codes, ordinances, rules, procedures, restrictions, and requirements, including but not limited to those concerning land use, zoning, building permits and requirements, rebuilding requirements, setbacks, height limitations, lot coverage restrictions, and allowable uses. So I don't know if this is a question. Maybe I'll make a statement. If you were to buy, if you wanted to know, let's say that you're looking in MLS and you see something that's kind of unusual. It's not zone your typical R5 or R75 or R35, but it's like A-1 or A-2. Does anyone know where you can find where the restrictions or the limitations are in terms of usage? Does anyone know where you can find that? Okay, so
I actually downloaded something that showed all of the usage. It had like a check what you could actually use it for, but I can't remember where it was.
Okay, it would be under the Land Use Ordinance. So that's a public document that you can download. There's a lot of pages to that, but there's a chart that I've referenced before that will tell you based on zoning, how many homes you can have on it, and what you can do with the property. So there's a summary page that you can look for that might help you to familiarize yourself with the different types of zonings and what some of the basic restrictions for use are. So I'd look for that when you have a chance. And Lisa, if you guys have it somewhere, maybe shoot that out.
Let me show them something. Hang on just a second. So
Okay.
Let me not share screen yet, but let me just make sure I find it.
Okay.
The
The other,
something that these guys miss a lot of times the opportunity for.
yeah, the acronym for that is LUO, Land Use Ordinance.
Okay, let
So
me
some
share
guys
this.
will refer to it as LUO.
Okay, so let me go back a second. What I did is I logged into Matrix. Can you guys all see this?
Yeah.
Up at the top, there's links. So it goes My Matrix, Search, Stats, Realist, Finance. I think what happens is you get used to looking here and you don't look to these other things like market.
Yeah,
If you
good.
haven't input a listing, you probably didn't go to inputs or an open house. So click on links. And if you scroll down, first of all, you should do this and take a look at everything that's here anyway. But there is a set of reference links that they set up. So you're going to scroll down to reference links.
Right there, LUO.
State of Hawaii land use map. So here's
Yep.
the map. And then there's some other codes, building permits, land use ordinance, DPP, PDF. So you'll see there's all kinds of resources here. I believe you can find the short-term rentals link here. I believe this is where I found it. So you'll see there's all kind of helpful tools, ADU resources, Humane Society. I mean, just all kinds of great stuff here.
Oh, that's
You get
awesome.
a lot of your questions answered by going to this page, including training for the tools that you have at your fingertips through the board.
Okay, perfect. So I would look under LUO, and then you can do some research, especially if somebody says, you know, I'm looking for a piece of land in a rural area, and then you find one and it has unusual zoning that you're not familiar with. That's a resource you can tap into just to get some basic information. And then from there, you can expand your knowledge by talking to people about that. But thanks, Lisa. That's awesome. Okay, so the property may also be subject to private restrictions, which include the encumbrances described in paragraph G2AI. Private restrictions can cover a wide range of issues, including but not limited to design standards and requirements for permits, approvals, setbacks, height limitations, lot coverage restrictions, and allowable uses, licenses, and easements, encroachment, common wall, private road, common driveway, and similar agreements, and condominium, cooperative, PUD, subdivision, homeowners, community association, or cluster development related matters, including maintenance fees, assessments, and other charges. That's a lot of stuff. So this is just a general disclosure that anyone buying, you know, be aware that in addition to what may be provided to you, there may be other restrictions as well. So I'll give you an example. I'm sure most know that Mililani has a lot of restrictions. One of which is if you have a home, even though from a city and county perspective, you're allowed to subdivide. Because let's say you have enough land, and based on the city and county zoning and the amount of land that's there, you may be able to subdivide or maybe even CPR. But Mililani, if it's part of the town association, has restrictive covenants that restrict you from doing that. And I think Hawaii Kai, in most Hawaii Kai areas, similar, as well as even in like Kahala, as an example. You're only allowed, based on restrictive covenants, one single family home. So you can't do an ADU in Kahala. You can't do an ADU in Mililani. You can't do most of Mililani. There's a small little area that you can. But even Hawaii Kai, I don't believe you can do an ADU. So that's an example of general disclosures that as a buyer, be aware, right? Be aware that there are restrictions on there that you need to know about in case you wanted to do something like that. Okay, B, building permits disclosure. Buyers aware that many residential properties do not have all building permits as required by county ordinances and or may not have been built according to the plans or building permits issued. Buyer understands that there are potential risks in purchasing any property on which unpermitted or non-compliant work has been done. Risks include, but not limited to, fines, discontinued use of the property, inability to rebuild, and requirement to remove or rebuild the affected area. All of the above could affect the appraised value and insurability of the property. So this is a big one in my mind, right? When we talk about Hawaii real estate, especially if it's not in a newer subdivision, if it's an older neighborhood, even in some of the newer neighborhoods, you've got situations where owners may have done renovation to their property. And the renovation that they did, in terms of complying with city and county building department requirements, it may very well meet those standards. But not all renovations, one, have owners put a permit for. So if there's no permit, then it's not, the lenders don't see that improvement as part of the value of the property, of the improvement. Two, if it's built, let's say, not to standards, then the buyer is at risk. Let's say that they did some plumbing work and then they drywalled over the plumbing work, and maybe the guy just did shoddy work, didn't get a permit, so it wasn't inspected. And then there was a leak to it that no one really knew about. And it went on for months or years. And then it created a mold-like situation. And then there's a health hazard, right? So there are reasons why the city wants to, besides taxes, there are other reasons why the city wants to have everyone submit permits and have inspections done for work that's done on the property. So you've got situations where it affects the lender, because let's say that you're buying a home that has a 1,600 square foot living space and they enclose the lanai, which is another 400 square feet. So your buyer goes in and says, hey, this is great. I've got 2,000 square feet under roof. They're putting minimal down. And appraiser comes in and says to the seller, where's a permit for the enclosure of the lanai? Because based on my records, I only see 1,600 square feet. I don't see 2,000. Well, then all of a sudden, the appraiser's there to help protect the lender. The lender then says, Mr. Buyer, I can only lend based on 1,600 square foot of living space, and then something less for the other 400 square feet, which then could affect the value, the appraised value of the property. Okay, so that's one issue. You got the lender, you've got the city and county. If the city finds out, and they have to investigate, if anyone complains about a home that seems to have unpermitted work done, then the city could inspect. The city could then make you get it permitted. They could have you remove it. And they could also fine you per day until whatever they require is done. So those are some of the things that, as a buyer, they need to be aware of, because any of those things could be a real hardship for the buyer. If they find out about it, they were unaware of it and they're unable to deal with it. So any questions on A or B so far? Okay, if no questions, I'm just going to go based on the board. Robert,
Hey, Fred, I'm just going to bring up something quickly as relevancy with this, because we've seen it with about 3 agents in the group in the last 6 months. Clients or the agent themselves, it's like you don't know what you don't know, which is not a criticism. It's just an experience issue. And in one case, a client was ready to sell their house and buy a lot and build a house on it. And didn't get, first of all, they really needed to sell before they could buy. But the really important part of this is this was zoned for agriculture.
Okay.
And so when you see these agriculturally zoned properties, they have remarkably different rules to them about what you can put on them. So it's even more than, can you add on an ADU, or can you, build a house on it? It's like you can't even build a permanent structure unless maybe it's servicing an agricultural use. So that's something, and the financing can be remarkably different as well.
Yes, yeah.
So
Yeah.
I just want to bring that up because it's come in front of a few of the new agents, and they'd probably be looking at all this and going, yeah, really not anything I'm dealing with. So sometimes you may not even know that that's the clause that's impacting you.
Yeah, as an agent, when you're helping a buyer buy a home, that what might be more common is an older home on Oahu, right? Where it was built in the 40s or the 50s or the 60s. You have really no clear drawings or plans for the home. All you might find would be sketches done by the tax department to kind of indicate the size of the home. So you become a detective at some point trying to determine, is this home all properly permitted? So Lisa, down the road, if it makes sense, maybe we can do something with a building permits package. How to look at it, how to investigate, what's there, and how to share with the buyer potentially what the issues could be, right? But at least that way they have an idea as to how to approach it.
Yeah, just so everybody knows, we had in one of our classes, I think about 3 or 4 weeks ago, probably 4 weeks ago, because of a little break that both Kit and I took. I did a session on showing you in Hawaii Information Services how you could change what was displayed to include the building permits. And we had a situation last night where an agent who actually had more experience than our agent called up and said, I don't think we can do this sale. And they just delivered the counteroffer signed. And so to panic, this agent calls me and says, I was just told we can't close escrow on this house because it shows a permit that says inspections in progress. And I said, I remembered the clients and I said, what year did your clients buy? 2014. I said, yeah, and that permit stated 2012. So clearly that just points out that you can transfer on a property that doesn't have permits. There are some cases where you cannot, and that has usually more to do with the lender. But having said all of that, what we figured out in looking at it is anytime there's any digits in the last 4 of the TMK, what will be displayed in that printout within Hawaii Information Services is permits for every property that has the remaining part of the TMK correct. So if you have 400 units in a condominium, you're going to see all the permits for 400 units. So what this agent did was saw it in Hawaii Information Systems, but didn't go to DPP and search on the permit number and find the address that it belonged to. And so you're going to have this happen with CPRs and with condos.
Yeah.
And then,
Yeah.
you know, after we talked about it for 15 minutes, we go, this doesn't even apply to this property.
Yeah. Yeah. When you talk about condos and trying to find permits, yeah, that's different than a single family home. Both of them are different. Both of them can be difficult.
Mhm.
Yeah. Yeah. Okay. Okay. So Robert, can you start with, why don't you read C and D? So stop after you're done with C, and then after that, continue to D.
Sure. Asbestos disclosure. Asbestos materials are hazardous to one's health, particularly if asbestos fibers are released into the air and inhaled. In the past, before 1979, but possibly since asbestos was commonly used in insulation materials in heating facilities, in certain types of floors and ceiling materials, shingles, plastered products, cement, and other building materials. Buyer is aware that buyers should make appropriate inquiries into possible instances of asbestos in, on, or at the property. Structures having popcorn or cottage cheese type ceilings may contain asbestos fibers or asbestos containing materials. Such ceilings should not be disturbed since it releases asbestos fibers into the air. Any disturbance should be done only by a licensed abatement contractor.
Okay, thanks. So, you know, if you have any client that is sensitive to asbestos, you know, well, you're going to talk to them about this regardless. And in fact, there's a lead-based paint addendum. But either way, for the asbestos, if they're sensitive to this, the question I'd ask is, if you are that sensitive to asbestos, then maybe you need to buy something that is newer than 1979. That's one way to approach it. If they're open to it, but they're still sensitive about it, you can say that, as an example, we've talked about, I've talked to clients before about popcorn ceiling. And I've explained that, you know, I'm not an expert in this, but my understanding is as long as it's not friable, as long as it's not airborne, if you don't inhale it, then it could be okay. And one way that you can deal with it, and what many sellers or owners have done in the past, is they would encapsulate. So they would spray it with paint, right? That's one way that they could encapsulate it so that it doesn't become airborne. And that's similar to lead-based paint. So the lead-based paint, it's if you ingest it, right? And so what a lot of, you know, over time, right, as an owner, you're going to repaint your home. So same thing, if they're really sensitive to lead-based paint, then 1978, don't buy anything older than that. You know, just one way of dealing with the possibility of asbestos concern and how to address it with a buyer. Lisa, any other suggestions on how you would go about explaining this to a buyer and how to deal with it? Because many times it's really about setting expectations.
Yeah, I think as far as setting expectations, you know, we've been talking about the buyer consultation, working with buyers. get used to having a packet that's ready when you do your buyer consultation. And if they're going to work with you, I would have a packet of the purchase contract, with a draft of it. You can print this out so it says draft across it. And there's certain things I would talk through and circle. And asbestos and lead would be two of them, and go ahead and give them the lead disclosure booklet. And we had an agent that since has graduated, actually had already graduated from PC when I was coaching her. She spent 11 months working with the buyer, got down to finally making offers on multiple properties, and then bailed on her when he realized that older properties had asbestos in the ceilings. And she could have just decided, if they'd had this conversation months before, they would have had to come to a different outcome by narrowing out all the older buildings.
Yeah, right, exactly.
So he's like, I only want a unit that's been scraped and painted. And then, we don't know if they scraped and painted it and had a licensed asbestos abatement contractor come in. So maybe I don't even want an older building.
Yep.
So that was like 10 months of looking for the wrong properties.
Yeah.
So put that as part of your consultation.
Yeah, because some are sensitive to these things, and everyone's different, so you can't fault them for that. That's just what their criteria is. Okay, thanks, Lisa. Robert, why don't you continue with D?
Okay, D, hazardous waste and toxic substance disclosure. Federal law and state laws place strict liabilities on properties owned for the dangers caused by hazardous waste material management, and may require such owners pay for the costs of the cleanup of the hazardous substances and other toxic substances. Buyer is aware that buyer should make appropriate inquiries into current and past use of the property and should seek environmental assessment as to ascertain the possible existences of such hazardous substances or materials on or under the property. Buyer is aware that buyer may have liability for hazardous substances located on or under the property, even if the buyer did not cause such substances to be on or under the property.
Okay, thanks. So that one, I don't really have much experience at all in dealing with that kind of situation, but I do know that, like, let's say you were to buy commercial property and there was a service station or like a Jiffy Lube where, they deal with that kind of oil and hazardous type of waste all the time. This just says buyer beware, because even though you didn't know about it, if there is hazardous substances under the property and you didn't cause it, you're still responsible for it. Okay, let's see. Joanne, can you read
So I got
E
a
and
quick
F?
question on that one.
Yeah.
Sorry, would a septic pool or something like that, would that apply to this? Like if
Like a cesspool?
cesspool of that was leaking, is that something that would apply in this section?
My guess is no. That's my guess. Because I've never heard of anyone being cited for that, and they still exist today. I think there are some out there that are still legal, but at some point there's a date, a fixed date that they're going to have to get off of cesspool and onto the city sewer connection. But that's my experience. I don't think they consider that to be hazardous waste.
I don't think so either. Predominantly, what you're going to be dealing with, and where we had a lot of issues with this, of course, my former homeland with California had some huge stuff, and my nickname was actually the Toxic Queen. We had to develop some special. I was board president. We were dealing with lawsuits over leaking underground fuel tanks and contaminated aquifers. Now we have a very different substructure to the island than a lot of places on the mainland, but not entirely. So where you'll see a lot of this, Robert, is near gas stations because their gas holding tanks leak. You'll see it where places may have had their own tanks, fuel tanks on a property. So like, look out in Waianae where people have like trucking companies and stuff. So it could be that kind of an issue. We also had a lot of issues where people ran auto repair shops, so paints and solvents, trichloroethylenes with dry cleaning companies. And trichloroethylene in California was used for cleaning wafers for the production of semiconductors. So you'll see trichloroethylenes, TCEs, appear in both dry cleaning shops and in anything where they're basically dunking and cleaning metal. And so you see it even in those shops that were in Kaka'ako where they would do sandblasting and stripping of chrome wheels and then polishing them. So a lot of the compounds they use for that. So people can do that on their own property. They can get those chemicals there. There is some issues now happening both with military bases because a lot of the lead that's been dropped in the ground. A lot of the properties they're selling off across the country has contamination from dropping, like test warheads and military shrapnel, oil, chemical contaminants for controlling pests. If anybody was around long enough, probably Kent and I were. Remember the heptachlor?
Mm.
So, and then, you have runoff from that. So even people that store and may leak things meant to kill weeds and control weeds and kill fungus and other things.
But sorry, just so I understand this, if you have a property you owned and they discovered, you didn't know about it, but they discovered later on that it does have some type of toxic material, you're liable for it, even though it happened way before your type of ownership?
Yep, that's what it says.
Okay.
The new buyer, the new owner, whoever the owner is responsible for it, the cleanup. Okay, Robert, kind of aligned with what your question was. I'll have Joanne, why don't you read E and F, but E covers cesspool.
Okay, well, because I was going to ask, since Robert brought up not being attached to the, sewer system, is there a separate inspection for that, or is that going to be in this?
Well, why don't you read that and then you can ask the question after that.
Okay. Wastewater disposal disclosure. The state of Hawaii Department of Health and individual counties may require upgrades from cesspools to septic tanks or connection of new systems in certain situations. Additionally, the Federal Environmental Protection Agency has issued regulations requiring that all large capacity cesspools be closed and converted to EPA approved systems by April 5th, 2005, or face substantial penalties. Buyers should contact the state of Hawaii Department of Health, the EPA, and the individual counties for additional information.
Okay, great. So yeah, it says individual counties may require upgrades from cesspools to septic tanks or connection to new systems in certain situations. So I've seen where a listing had a cesspool and they did disclose that it needed to be connected to the city's wastewater system by X date. I don't recall the date, but that one listing did have a requirement from wastewater for that connection. And after reading this, going back to Robert's question, yeah, it doesn't sound like cesspools would be considered hazardous waste based on Section D. So yeah, that kind of helps to clear it up a little bit. And then you had a question, Joanne, about E?
So if they have a septic tank, is that part of the inspection, or is there a separate inspection for that? How is that handled?
That's a good question. You mean when let's say you're going to buy one with a septic tank?
Yeah.
That's a good question. I've only represented one that had an abandoned cesspool, but I don't have any experience with active cesspools or septic tanks. So I'm not sure. Yeah, go ahead, Lisa.
Yeah, you definitely want a separate inspection because the things that can happen, there's different ways that tanks are built too. So I've sold properties where the tanks were built out of wood, which I hope they haven't done here for ages because it just rots, right? And the tops collapse, but that's what they used to do. Or they built them like they built the cesspools, right? There's just tiles, like concrete tiles and a cover on them. They can collapse the leach fields, there's all kinds of things that can happen. Right before I moved here, I had a $70,000 lawsuit over a failed leach field on a like $400,000 house.
Oh.
And the buyer was trying to say that the seller did things or their contractors did things. And in reality, what had happened is that there had been heavy rains and a nearby river had overflowed and had flooded that part of the property where the leach field was. And when that happens, it can clog up the leach field and then it backs up the tank into the house. So, we were able to show, hey, you didn't live in that house for 5 months after you bought it. And in that time there was a rain and this could happen. And they didn't do an inspection. They chose not to do an inspection. They just asked for the tank to be swapped out, which it was done. So it's important to check out the tanks. I had one here that my clients were going to make an offer on, and we were very concerned that the agent from Coldwell Banker was not disclosing appropriately what was going on. And we had some, what I call rumor, whispers down the lane. And on a small island, you get whispers down the lane a lot more, where neighbors are talking to neighbors and somebody knows somebody that knows somebody. And so in this property that was on the waterfront, we were pretty sure that the leach field was failing and that the tank was not the right capacity. What we come to find out is there was a lot of unpermitted work. So we go back to page 6. And when the unpermitted work consisted of adding on extra bedrooms. And there is a limitation on this island for the number of bedrooms to the size of septic tank. And so it may not even be about the function of it, but an inspector that does septic tanks, they usually call them honeypot men, by the way. Then think about that.
Honeypot what?
Honeypot men.
Oh.
It's called honeypot. Think of it. It's disgusting. Anyway, what happened in this case is not only was the house expanded, it was expanded to the extent that you couldn't have a single septic tank serving the property. You would have needed to have 2 septic tanks on the property, and to have 2 septic tanks on a property, you had to have a certain square footage, which this lot didn't have. So imagine if you did that and then you went back to get a permit and a lender required the permit, you wouldn't be able to get the permit.
Yeah.
So definitely, if you're buying a property with a cesspool or septic tank, your client should be talking to a company that does septic tanks, getting a cost of what it's going to take, what's going to happen, what's the cost going to be, and is that tank functioning correctly and the leach field functioning correctly, and is it the right size for the house? Because otherwise nasty things flow back into the house.
So is that something that like they would put in disclosures, and then if you wanted that inspection, you could add it in queue, or what? How does that generally?
It's part of your J1, so part of your J1 is in Hawaii, we're pretty much like J1, call one guy, do an inspection. But that really shouldn't be what we're doing. We should be looking at the property, and if it needs a septic tank or cesspool inspection, we should be getting that. If it needs a roof inspection, if we're seeing water leaks and missing tiles, we should be getting a roof assessment. If we're seeing pitted pipes and leaking pipes, we should get a plumbing inspection. If we're seeing old knob and tube, they ought to get an electrical inspection. And all of that falls under your J1 criteria.
Okay.
So
at the buyer's expense.
I'm sorry?
At the buyer's expense.
Yes.
Okay.
And do sellers always disclose? I will tell you, we kept talking to this agent, and the seller lives on the mainland. He lives in Arizona. He's licensed. I'm sure he would disclose it. Oh no, there's no problems. Well, my buyer knew the person that was a caretaker living in the little side house. She goes, that's funny because my shower is full of excrement that's flowed back in, and they have this company come out and pump the tank 3 times a month.
Wow.
And so they're trying to say, it's just 3 times a month because we're using it as short-term rentals.
Yeah.
So, well, that still shouldn't do it.
Yeah.
So people don't always disclose what they should.
Yeah, man, and don't rely on verbal. Make notes, confirm with emails, make sure that everything is properly documented. Okay, why don't you do E? Finish E.
We did E, so F.
Oh, F, sorry. Yes, F.
Mold disclosure. Mold and/or other microscopic organisms may exist in, on, or at the property. Molds are simple microscopic organisms present everywhere. Mold spores may cause health problems. Mold will grow and multiply whenever sufficient moisture, temperature, and organic material are present. Brokerage firms, brokers, and agents are not qualified to inspect the property for mold or to make recommendations or determinations concerning possible health or safety issues. More information is available at the EPA's website.
Yeah, so I've seen a couple of situations where there was mold, and by all means, allowing the buyers to do their own tests and make sure that they're satisfied with it before they move forward is important, because as a seller, you don't want to be liable for selling something where it's maybe questionable that whether or not it's been properly disclosed and whether or not the buyer had ample time to do their own investigation of that. And as a buyer, obviously, right, you don't want to buy into something that may require a lot of work down the road. So a simple one might be you're going to buy a house, whether it's a condo or a single family home. You do an inspection and you find that through the inspection report, maybe one of the shower stalls, maybe the pipe is loose, or there's maybe some moisture that's detected, behind the wall where the controls are for the shower head. Those things are important to further investigate, because as it says here, right, certain conditions will allow mold to grow. Moisture, heat, organic material are present. That's where mold will grow. So what may start off as just something really minor in your mind, that it's just maybe a leaky valve that can be repaired later. My recommendation would be to do a further investigation on that, because you don't want to be in a situation where you close on a property and then the buyer 2 months later calls you and says, "Hey Ken, I found mold growing. It's penetrating now through the drywall. What am I going to do?" Right? That's a difficult situation to be in. So, not saying that you'd be at fault at that point, but if you find things, moisture of any sort, behind the toilet, behind the shower, behind the sink, moisture detected anywhere, to me, should be further investigated, because if you don't, it could lead to things like mold. And if there's mold growth in the back, it may not be a simple fix. It may be where you have to cut out drywall and replace it and repaint. It could lead to a lot of unpleasant situations. So just be aware for the mold, not only this disclosure, but also if you represent the buyer or the seller, how important it is to handle moisture, discovery of moisture, how to handle it carefully, and don't gloss over that, because it could lead to something worse down the road. Any questions on F? Okay, let's see who's next. Shaylee? How about G and H?
Okay. Sex offender registration, Megan's Law. Hawaii law requires sex offenders to register with the state attorney general's office. Buyer may contact the Department of the Attorney General or visit its website for information regarding sex offenders who have registered with the state of Hawaii. And
Okay.
H. You want me to pause?
Nope, I think you can go ahead unless anyone has a question.
Okay. H, flood zone. The property may be located in an area which is a flood hazard zone. Lenders may require buyer to purchase flood insurance in order to obtain any loan secured by the property. Buyer is advised that flood insurance premiums may increase significantly based upon FEMA flood zone designations. Changes to flood zone maps are FEMA requirements. Buyer is further advised to consult with buyer's insurance agent and contact the National Flood Insurance Office for more information. In addition, various governmental agencies have special requirements for obtaining building permits for properties located in flood hazards districts.
Yeah, okay, thank you. So, yeah, that one is also kind of tucked away back in here under this H section within this large disclosure section. But know that, you know, the flood zone properties may not only be by the ocean, it could be near a river as well. And the impact to the buyer could be significant. You would find the flood zone classification, I guess, on your, what is that Hawaii information printout of the property. I think it would tell you the zoning. So one is, as it says, right, if it's in a flood zone or a flood fringe zone, it could require that the buyer obtain flood insurance. I mean, it could be thousands of dollars a year. So added cost, right? That's one. The second thing is that it could affect the buyer's or the owner's ability to renovate or to add to that property. Because in certain areas, because of the possibility of flooding, one, they may not allow you to expand the footprint. Because if you expand the footprint of the property, it causes water displacement to go further out, which then could cause further flooding for other people that are maybe not even in the flood zone area. So one, it may limit you as to how much you can add square footage, as well as it may limit the amount of value that you can add to the property. So be aware of that. It could impact them from an insurance perspective, and it could impact them from a building or renovation perspective as well. Okay. Chihiro, why don't you read I and J?
I and J. Okay, lead-based paint. Federal law requires that the seller of any interest in residential real property must provide the buyer with any information on lead-based paint hazards from risk assessment or inspection in the seller's possession, and notify the buyer of any known lead-based paint hazards. Residential dwellings building prior to 1978 may present exposure to lead from lead-based paint that may place young children at risk of developing lead poisoning. Lead poisoning also possess a particular risk to pregnant women. More information is available at the EPA website.
Okay, thanks for that. So you all know that there is a lead-based paint addendum, and basically it says that it requires the seller to disclose what they know. Do they have any reports? Are they aware of any lead-based paint? Typically, you're going to see that the sellers are unaware and have no reports. And then it'll also ask buyer or tell buyer that they have the right to do an inspection. So it's up to them. So for both lead-based paint and for asbestos, samples can be taken and can be given to a testing site. I don't know of any offhand, but you are able to do that if it's something really sensitive that your buyer is sensitive about. You can take samples to these testing centers, and they can test for it. Now, know that before you take a sample, you need approval from the seller, because you're not able to just randomly take a sample and damage their home without their consent. Lead-based paint, you probably just scrape some paint off, and normally I think it's like an inch or 2 inch square that you might need. So it's pretty decent size. And then for asbestos, I'm thinking something similar where you have a decent sized sample in order to test for that. But again, same thing with lead-based paint. If it's been painted, for many that's good enough, because they consider it at that point to be encapsulated, thus limiting, I guess, the risk of poisoning, lead-based paint poisoning. Okay. Any questions on H or I?
Hey, I want to give a little admonition to everybody because it is often missed in this. So this is a federal law that requires that. It's not a state law. And there are significant penalties if you don't follow the law in this regard. The provision of the booklet, Protect Your Family from Lead in the Home, is actually a seller requirement. And I've never in my entire career seen a seller actually hand it off to the buyer's agent to give it to the buyer. So just by business practice, we end up handing it to our buyers to prevent problems. But if you're really an ace listing agent, you know the law, you'd be doing that. You'd be putting your Protect Your Family from Lead brochure in the MLS as associated documents. And you would put the lead disclosure up there completed by your seller. Because the federal law requires that addendum is with the contract at formation. So that means every listing agent ought to have their seller fill it out and put it into the MLS so that the buyer can then sign it and submit it with the contract. More often than not, what we're doing is we're submitting a lead-based paint addendum with our offer. And when you use DocuSign or digital ink inside of zip forms, it will automatically populate the signatures at the bottom. By using those signatures before it's completed at the top, you are creating an issue legally called interlineation, which means you're going to make it look like it was signed after the seller completed it, and they did not. Easily find-outable, not a good, easily researched and proven to be wrong. So what you want to do in that case is only initial that your buyer was given the booklet, send it with the offer for the seller to complete the disclosure, and then all the rest of it will be signed after the disclosure is complete. And at that time, your client can check the box, or you can check it for them that says they're either conducting an inspection or they're waiving it. So here, let me give you just a quick view of this. The potential penalties for violating the law includes joint and several liability to a purchaser or a lessee equal to 3 times the amount of damages incurred for a person who knowingly violates the requirements of the law. And there's other civil penalties to the US government. And the last time I read this, I think the penalty is either $10,000 or $12,000. And they can award attorney's fees, costs, and expert witness fees. So that means you could end up by blowing this law. I don't think they'll ever enforce it because it's so old. But let's say that somebody asserts that their child chewed on the wall or the windowsill and ingested lead, and now you're going to get medical bills. You're going to get the cost to strip all the paint and all the woodwork and put new paint in, and their lawyer's fees and the expert witnesses and all the tests times 3, plus civil penalties. So I don't think the EPA is going to send investigators to Hawaii, but it's such a simple law to follow correctly, and it's violated every day.
Yeah, for sure. Yep. Actually, good segue into J. Jesse, why don't you read J?
Okay. J, lead-based paint renovation, repair, and painting. In residential real property, the EPA under the Toxic Substance Control Act issued a rule to address lead-based paint hazards created by renovation, repair, and painting activities that disturb lead-based paint. These rules establish requirements for training renovators, other renovation workers, dust sampling technicians, and renovation firms for accrediting providers of renovation and dust sampling technician training to meet the new federal requirements effective as of April 22nd, 2010, or substantial penalties may apply. The rule applies to pay contractors working in pre-1978 housing, residential, public, or commercial buildings, and all rental housing. Childcare facilities and schools with lead-based paint. Contractors include home improvement contractors, maintenance workers in multifamily housing, painters, and other specialty trades. Federal law may require that buyers be provided with the lead-safe certified guide to renovate right. Important net hazard information for families, child care providers, and school pamphlet. More information is available at the EPA website.
Yeah, so this is interesting, right? They're saying if you're going to renovate a home pre-1978, that the guys doing the work need to be trained. The reality is, maybe they all are, but it's never a question I've ever asked a contractor whether or not they know of these rules and whether or not they are, I guess, certified. Maybe they don't have to be certified, but aware of how to deal with homes that are pre-78 because of lead-based paint. So I guess on this one, it's just be aware of this, be aware of it. I don't know what else to say on this one. Lisa, you got anything on this one?
Yeah, I mean, this is state by state. I've seen other states actually require this to get permits, so I don't know if they'll ever do it here. You know, it has a lot more to do, especially if you're bead blasting or sanding.
Yeah, I mean, if you're gonna renovate, you definitely are gonna, and there's lead-based paint, you are disturbing it.
Absolutely.
So, but I don't know if anyone takes special precautions when doing renovation work because it's an older home.
You know, really what the board is doing for us, what the state association is doing for us, and all the associations speak to one another, right? They go to NAR meetings.
Yeah.
And so this has come up, you know, I think the lead-based paint issue really started in New York with the tenement housing.
Mhm.
And of course, once something ends up being a big deal somewhere legally, California jumps on in a big way. The attorneys, you know, per capita number of attorneys is huge. Things don't ever get to the same height here that they do in other places. But California was requiring, if there was any paint work done on a house of that age, you'd have to hire one that had a certain certificate with the contractor state license board. So I think all they're doing here is they're protecting us by, a buyer can never say, I didn't know this.
Yeah.
They'll say, what was in the contract you signed? But in reality, I've not seen anybody following this in the state of Hawaii.
Yeah. Okay. Yeah, it's interesting that you read this contract again and again and again, and then it's all based on where you are at that point in time where you see something new, right? I mean,
Absolutely.
I read this many times, and after reading it today, I go, yeah, I don't recall this specifically, but good to know. Okay, Teresa, why don't you read K and L? Yeah, K and L.
Okay, K, climate changes and natural hazards. Climate changes, including sea level rise, could affect properties in Hawaii, particularly those at the shoreline and coastal areas. All properties in Hawaii are also subject to natural hazards such as hurricanes, storms, earthquakes, tsunamis, floods, landslides, etc. Buyer is advised to consult experts of buyer's choice regarding any questions concerning the effects of climate changes and natural hazards that may affect the property. For more information, visit the Hawaii Climate Adaptation Portal, climateadaptation.hawaii.gov.
Okay, so pause there. Yeah, I think with time, this will become more and more of an issue. We already see in the news, right? All the North Shore and the Lanikai properties that the beach has been swept away from the tides, and they're putting barriers up to try and reduce erosion. But with global warming, seas rising, I think especially those properties being at the values that they are, we're going to see more and more of these climate change issues happening to those properties. That's just my opinion on that. So just be aware, right? As a buyer, if they're gonna buy a shoreline property, you got a little bit more due diligence to make sure that they know what they're buying. You don't want to have them call you buy a North Shore property in the summertime where there's a huge beach, and then come winter, all the sand is gone. So Just buyer beware on that. Any questions on K? Okay, why don't you continue with L?
Okay, L, wired funds and sensitive personal information warning. Criminal hackers are targeting email accounts of various parties involved in a real estate transaction. For example, lawyers, escrow representatives, mortgage brokers, brokerage firms, real estate licensees, to divert funds to the criminal's hacker's bank account. If you receive an email containing wiring instructions or a request for sensitive personal information from someone appearing to be involved in this transaction, you should call them at a telephone number that you obtain from a source other than from the email. For example, the purchase contract, their website, etc., to be sure that you are contacting a legitimate party.
Okay, thank you. So on that one, just be aware that the bad guys can find out when somebody's opening escrow. I guess they find emails or they can grab emails, determine that, and then posed as the escrow company and have the buyer wire money to the wrong account. And then unfortunately, once the money is wired, it's like handing a wad of cash to the other guy. It's gone. So just be aware that guys have been victimized in the past. So if they're ever going to wire money, make sure that they not only that they verify the information that they get online before sending the money over. And that means in most cases, right, you're going to call your escrow officer and you confirm the accounts and the procedures that that they provided, that it's accurate before wiring the money over, because it has happened more than once. Any questions on L? No? Okay. Tori, why don't you read J1?
Okay. J1, general inspection of property contingency. At buyer's sole cost and expense, buyer shall have the right to, personally or by any expert, professional, or other representatives of buyer's choice, A, inspect the property or any portion thereof, B, inspect all major appliances and fixtures, plumbing, electric, and gas included in the sale, C, inspect all public records relating to the property and its use, and D, review all matters concerning the property, including those described in paragraph I6. L6, seller shall provide buyer and buyer's representatives access to the property for inspection during reasonable hours with reasonable prior notice to seller. The obligation of buyer to purchase the property is contingent upon buyer's approval of inspections and review of all matters described in paragraphs I6 within blank days after the acceptance date. All inspections and reviews must be completed within this time period. Seller agrees that the property inspection requires that the utilities be turned on, including propane, if applicable, at seller's expense. If buyer disapproves of the inspection or review results within the specified time period, buyer may elect to terminate this purchase contract pursuant to paragraph 02. The buyer's rights under this paragraph do not affect buyer's rights and timelines under section L. If buyer fails to make an election in writing to terminate this purchase contract within the specified time period, then buyer will have waived this contingency.
Okay, so this is as a buyer or as a seller, but primarily as a buyer. This is, they're probably one of the busiest times of the transaction, right? Is their inspection period. So in big bold, it says if buyer fails to make an election in writing to terminate the purchase contract within specified time period, then buyer will have waived this contingency. So what that says is if I have a 10-day J1 and I've opened escrow, let's say I opened it on the 1st. If I don't make my determination or if I don't elect to cancel by the 10th day, on the 11th day, that means that I've accepted J1 and I can no longer cancel or negotiate anything based on J1. I've waived it. Okay, so I'm sure you guys are all aware of that, that within J1, you have to complete all your inspections, complete all your negotiations for conditions or credits. You need to have that all done within J1. Only way that you can extend it is if both parties, both buyer and seller, agree to extend the time frame of J1, right? The termination clause is O2, and O2 says you've got to make a decision within the time frame. And typically I see J1 being 10 days, right? So as a buyer, I open up escrow. The market's really busy right now. Home inspectors are running like crazy, especially the good ones. They don't have availability. I open escrow. I have a 10-day J1 time frame. I call all my inspectors. Best I can get is somebody to go out there 8 days later. So I'm a new agent. I go, okay, I can get my inspection done on the 8th day. I have 2 days left. No problem. Inspector goes out, does the inspection. Maybe he gets tied up. Maybe he doesn't give you the report. You know, he gives you a verbal on the day of the inspection. And I'd highly recommend that, one, they get an inspection. If they don't get an inspection, have it in writing from the buyer that they waived it. Okay, because there is a cost to do an inspection. So recommend to the buyer, highly recommend you get an inspection. Explain what the inspector's role is. That typically the inspector is a generalist. They'll look at everything that they can. They can't look behind walls though. So non-intrusive, they can't damage things to inspect. But they're generalists. They'll give you another set of eyes as to the condition that they see of the property. So get an inspection. 2, have the buyer show up. At the conclusion of the inspection by the inspector, your inspector should give the buyer a summary and walk the property, whether it's a condo or a single family home, and tell you all that they've discovered, right? Good or bad. And then 3, get a report from the inspector. Now, the report is then used by the buyer to make a determination along with the verbal summary, whether or not it is what they thought they were buying. If it's not what they thought they were buying, that's an opportunity for you to cancel. If it's still somewhat what you thought you were buying, but the fixes to the problems that were discovered that you were unaware of and the buyer was unaware of requires more money than they have and they're not comfortable moving forward, then that's when you negotiate with the other side, either for a repair, but more typically a credit towards closing, something of that sort. Now, the reason I said 8 days and then you get the report back on the 9th day, we talked about it earlier in the general inspections or general disclosures, right? And it said, hey, if you're sensitive to mold, if you're sensitive to asbestos, if you have a problem with the plumbing, if you have a question about a building permits package, solve that during J1. So now all of a sudden you do your inspection, you realize, shoots, I don't think that my plumbing is in as good condition as I thought it was. So Lisa said, yeah, you want to go hire maybe a plumber or somebody that is more suitable to give you a better opinion as to the condition of whatever it is. It could be plumbing, it could be your electrical, it could be your roofing. So you see where I'm going, right? 10-day J1, you do your inspection on the 8th day, you have 2 days left. And now you're stuck going, you know what? I don't think the plumbing is as good of a condition as buyer thought it was going to be. And now the buyer is all concerned and may not want to move forward because the buyer is unaware of what it would cost to solve that problem. Or electrical, maybe the panel is double tap electrical and the panel needs to be replaced, right? So where I'm going with this is, even though you have 10 days or 15, doesn't matter, whatever amount of days you have, your general inspection is great within, but leave yourself with enough runway that if you need to bring in somebody else, you have time to do that. So if I've got a 10-day J1, I want to do my inspection ideally no later than the 5th day, because then I have another 5 days to deal with whatever comes up from the inspection. Because one, I got to get somebody else back out there. And then two, I got to discuss with the buyer how they feel about it and what they would like me to do with the seller. And then if I got to negotiate with the seller's agent, I have time to position, to provide the information, to provide the request, and then to negotiate before we come to a settlement before a J1 expires. Okay, so J1, again, a lot of stuff going on. You need to have all your inspectors and your roofers, all those, you need contacts, because in the event that something comes up, you can make a quick call and hopefully they can come out within a reasonable amount of time to help you deal with that situation. Okay, so let me ask, any questions on J1?
Yeah, I have a question. Since I've been doing this just this year, I mean, I've only heard of people always doing 10-day for J1 with like older properties or multi-dwellings or just things that need a lot of work. Do people extend or like maybe do 2 weeks? Or, I mean, I've really only heard of 10 days, so I'm just wondering how often is something different?
Yeah, that's a good question. So I would say that generally speaking, if it's competitive, you're going to go 10 days. You might even go 7 days. But yes, you're going to make that assessment when you're looking at the property going, either the buyer is going to renovate, so maybe it's not as critical. But if they're going to keep it and live in it, then it is critical that you have enough time for the inspection. If it's a bigger home, if it's an older home, if it has, multiple kitchens, if you suspect problems, especially if it's not competitive, I'd go at least 15. I'd go 20 if you can, right? The more time, the better. So that.
But in this market, that would be against.
So, well, I'd say we've seen, if you're dealing with an older, bigger house, you're not in Eva Beach with something that's 10 years old. I've seen contracts that are pretty typically for houses 14 days.
Yeah.
And we really would like to see 21. The one I did on the Big Island, which was a big house with a septic tank and needed, multiple inspections. We did 21 on that and got it, but we were at the very tail end. They didn't know the market had shifted yet.
So along those lines, I just closed on one where it was a luxury home, and because it sat on the market for a while, we were able to get, what was it? I think it was 21 days or 20 days, something like that. Because we knew that there were going to be a lot of things that we would have to deal with. And because there was not a lot of competition. So we were able to push a lot of the contingencies towards the favor of the buyer, just because it was not competitive or it didn't appear to be at that time. So if you have the flexibility, then get it.
Okay. Okay.
Yeah. Did you have another question? A follow-up to that?
Nope.
Yeah. So I would just stress, there's a lot of due diligence that goes on. So with this property that we just closed on, within J1, I had talked to the seller's agent. I had talked to the contractor, which was first time I've ever talked to a seller's contractor regarding work that was done on the property. So I was able to get from the contractor all this information regarding the renovation, and it was pretty extensive, right? But the work was done as more of a repair, so it didn't require building permits. Okay, let me back up. City and county building permits, when you look at the requirement for a permit, it's almost anything you do, you require a permit. But you talk to contractors, they'll say that, if you're just going to redo things, but keep everything kind of in its place, electrical and plumbing, you're just it's more of a like a maintenance thing where it's an old sink, you have to replace it, then typically the city looks the other way. So in this case, they redid flooring, they redid the kitchen, they left everything in the same location though, in terms of where the sink is, where the refrigerator is, but it was very extensive. Point is, I got all this information during J1, sent it over to the buyer so that they were aware of it. There was a city and county setback that they had applied to the property. So I went in and I found out more about that. Looked into DPP to see if there was anything there. I called somebody from DPP, found out more about that, disclosed that to the buyer. So the point is, there's a lot of things potentially that as a buyer, they would want to know, but they may not even know to ask. And this is where, the more you know and the more time you have, the better due diligence you can do on behalf of the buyer, right? So get as much time as you can, and then just be aware when these little things come up, it may require you to look deeper into them. Okay, so that should go without saying. J1 is probably the one thing that everyone, when they first start, they're focused on because, again, that's where all the action takes place in the beginning. Okay, any other questions on J1? Okay, all right, so Miranda, can you read J2 and J3?
Sure, hang on just one second. All right, J2, recommendation. Can everyone hear me okay?
Yes.
Okay. J2, recommendation regarding home inspection. It is strongly recommended that buyer obtain a home inspection as well as inspections in specialized areas beyond the scope of the standard home inspection service.
Okay, yeah, pause right there. So beyond the scope of a standard home inspection service. So I would say that a pool, a sewer line, if it's a home older than, say, I don't know, 40 years, 50 years, you probably want to scope the sewer line. And then anything discovered during your home inspection, gas line. So before the home inspection, if they have gas, if they have a pool, if the home is older than, say, 40 or 50 years, I would start to line up those additional inspections because your home inspector typically will not do those 3 types of inspections. Okay. And then be ready after that, based on the inspection, to get another quote for, say, electrical work or plumbing work or roofing, and then painting and those other things. But at a minimum, when it says beyond the scope of a standard home inspection, it would be, gas, solar PV would be another one, a sewer line, and a pull system. Okay. Okay, why don't you continue with J3?
3, property condition maintenance and final walkthrough. Seller shall maintain the interior and exterior of the property, including all inclusions, in the same condition as when buyer inspected the property pursuant to paragraph J1, or as otherwise repaired and or corrected as agreed to in writing between buyer and seller. Buyer and or buyer's representative shall have the right to conduct a final walkthrough of the property no later than blank days prior to closing. A, to confirm the property is in the same condition and on that date, on the date that buyer inspected the property pursuant to paragraph J1, and or B, to inspect any repairs and or corrections made by the seller as agreed to in writing between buyer and seller. Seller understands that the final walkthrough requires that the utilities be on, including propane, if applicable, at the seller's expense. If the property has not been maintained or repaired and or corrected as agreed to in writing between buyer and seller, then the provisions of paragraph J4 shall apply. And buyer shall have the right to repeat the final walkthrough of the property after repairs are completed and prior to closing. If buyer and or buyer's representative fails to conduct the final walkthrough within the specified time frame, buyer will have waived this right.
Okay, thank you. So there's a lot going on with this one as well, right? So last sentence is, if you don't do your final walkthrough within the time specified, you have waived your right. So that's a scary thought. If you don't do it when you're supposed to, you forget about it, or, for whatever reason, it doesn't happen. It says right there, you waive your right to do your final walkthrough. And I would not want to be in that situation. So normally you're going, 3 days, 4 days, 5 days prior to close, you're going to do a final walkthrough. So make sure you're aware, what is that date? And it's calendar days, not work days, right? Keeping the property in the same condition. So both in and out. So as a seller, if your property is very nicely maintained inside and so is your grass on the outside, and then, the seller moves off island and fails to tell the yard guy to come back again, and now there's all tall grass growing. Well, this says seller needs to maintain the property interior and exterior, same condition. So guess what? The buyer has the right to come back to the seller and say, hey, you better cut the grass because it's tall now. It's like weeds out there. So you got to go and maintain that, right? It also talks in here about making sure that everything is on, and that you have the right to go and re-inspect if it has not been done properly. Okay. And then J4, why don't you read, Miranda, read J4. If you're still there, Miranda. Okay, let me read J4. So if it's not in the same condition when you do your walkthrough, then J4 will apply. So if seller has failed to maintain the property pursuant to paragraph J3, or has not completed any agreed upon repairs and or corrections no later than the time period specified in paragraph J3, the parties agree that 150% of the estimated cost shall be withheld, collected from seller and retained in escrow until completion. Parties shall immediately sign escrow formal withholding and disbursement instructions agreement, confirming the withholding set forth in this paragraph. All bills for maintenance and repairs corrections will be paid through escrow. Any balance remaining after the completion of all maintenance, repairs, and corrections shall be returned to seller, provided, however, that if maintenance and repairs corrections are not completed by, choose one, by closing or within X days after closing, said funds will be dispersed to buyer. So buyer finds something that was wrong, seller agrees to correct it. You do the walkthrough, it has not been corrected. Then buyer notifies seller, hey, you haven't corrected it, and can redo the final walkthrough. As long as it's not after closing, obviously, because once you close, you close. If they don't have it completed by that second inspection, then you can notify escrow that that broken washing machine has not been fixed yet. And I estimate that it's going to cost $500 to repair it. So escrow, I want you to withhold 150% of that until seller repairs it. And I put down here that on the contract, if it's not done by closing, then you're going to disperse the funds to me because it hasn't been repaired. So understand that even though it sounds like it's an automatic thing, when I go and tell escrow, hey, withhold 150% of 500 for the washing machine repair, seller still needs to agree to that. Escrow will not go based solely on what the buyer requests. Okay, so just be aware of that. It's not as a slam dunk as it appears under J4. Any questions on that? Okay, what time is it now?
Yeah, I have a question.
Yeah, go ahead.
If seller doesn't agree to withholding the funds, what is the next process? What's the next step?
It's between buyer and seller to come to an agreement. So it says that you're supposed to do it. It really doesn't say what happens if you can't come to an agreement. So I think you might just get into a situation where there's a dispute, and so maybe you don't close, and it'll get ugly at that point where you don't want to close, so you're not going to fund your loan, and seller's going to say you're in escrow, you got to close. So I haven't been in that kind of situation. Maybe Lisa, have you been? Can you comment on that?
Yeah, way too many times, because usually you end up, and not so much here, but you end up, my broker's bigger than your broker, threatening attorneys, blah, blah, blah. And in reality, the reason there is no clear path is because there always is a set of legal arguments to this. And you guys have heard me joke, it's, how do you resolve an argument? You watch the two clients, lawyers stand nose to nose, toe to toe, ripping up $100 bills as fast as they can. So you want to try to eliminate those outcomes. It's one of the reasons I would just say, you're supposed to have the work done, so we're not going to close. I wouldn't close and have anything major done. If it's something minor and it's truly there, most times they'll just fess up and get it paid. Frankly, a lot of agents, if their clients are being ridiculous, will just say, I'll give your client the $300 or $400. But if it's significant, I'd be advising my clients not to close anyway. And if there's a dispute, and you can't get the two brokers to work it out, so you go to me or you go to Chad, and they go to their broker if they do have a broker. And a lot of the problems here is we have a lot of independents, so they don't have anybody where clearer heads prevail. But you try to, and boy, just about two names just danced across my head on that situation. Squirrel. If the two brokers can't resolve it, you're just going to have to tell them to get legal advice and see what an attorney advises them based on the facts of the situation. So it doesn't happen very often here.
Yeah, I've not really seen that myself, but I think as Lisa pointed out, right, the small things, you may not like it, but perhaps you've got to step up and say, I'll take care of it after, or do something of that sort. But if it's a large thing, yeah, that could get ugly really fast, because you're talking about if you can't close and your loan lock expires, and there's at some point a point of no return, right? You're like, I'm not closing, and all the things that I've lined up to be able to close are not available to me anymore, such as my loan. Well, then I'm not going to close. And then, it becomes ugly really fast at that point. So hopefully nobody runs into that situation.
Those are actually pretty easy, right? Because if it's a big deal and one party is clearly wrong, attorney's going to be all over that. And they're going to call the seller and their attorney and say, the value of my client using the loan lock is, $40,000. You were supposed to do that. The cost of that is this. And we'll put a Liz pendants on your property so you can't sell it to anybody else. You're in breach. And usually a fairly decent attorney can get it resolved pretty quickly, negotiate it. It's just the ones between small and medium are the ones that can become a problem.
Okay. That's good to hear, Lisa. The big ones, so not that you don't want to worry about it, but I guess there's a clearer path
to
resolution, but it's the mid one, the ones that are just a little too much to absorb, that are, I guess, difficult to deal with. Okay, J5, no continuing warranty. Buyer understands that there is no continuing warranty expressed or implied after closing regarding the interior or exterior of the property. J6, home warranty programs. Buyer understands that buyer may obtain from a third party for a fee home warranties covering appliances, electrical and or gas and plumbing fixtures and equipment and other items included with the property. J7, existing warranties, plans, etc. Seller shall provide to buyer at closing, if such items are in seller's possession, any warranty documents covering the improvements and all other property being sold. Instruction booklets covering the appliances being sold, and blueprints, specifications, architectural and engineering drawings relating to the property, which may not reflect improvements as built. Buyer understands that A, any warranties delivered by seller to buyer represents obligations of other to buyer represent obligations of other persons or entities, not seller. B, the warranties and other documents are provided for informational purposes only. And C, seller does not promise that such warranties are transferable to buyer. And D, buyer must contact the providers of such warranties to determine whether the warranties are transferable to buyer. So normally, as a seller, they check that off and provide whatever they have. So it's whatever is available or whatever the seller has in seller's possession. H, removal of items from property no later than X days prior to closing. Seller at seller's expense shall remove all trash and junk, both inside and outside the property. Seller shall remove all remaining personal belongings from the property. However, seller may inhabit the property until closing date. No items may be left in trash bins or for bulky item pickup. Should seller not comply with the specified time period, the provisions of J4 shall apply. After the specified time period in J4, buyers shall have the right to keep or dispose of all items. So for that, for removal of items, a best practice might be to walk around at final walkthrough. And if you see junk that needs to be removed, I will take pictures because that's probably easier than having to describe everything that needs to be removed. But I take pictures and then email them off to the seller's agent saying, please remove these items per the contract. We did check J8. So you do need to remove all junk from the property and deal with it that way. Any questions on J5, 6, 7, or 8? Okay, no questions. I'm going to go to the bottom of, or just finish J and then we'll conclude for the day. So cleaning, no later than X days prior to closing, seller shall at seller's expense have the interior of the improvements on the property cleaned. Cleaning shall include all appliances, cupboards, drawers, floors, jalousies, screens, and windows. Seller shall also have the interior carpets professionally shampooed. Should seller not comply with specified time period, the provisions of J4 shall apply. So again, J4 is it's done by final walkthrough, right? The seller shall have the entire property professionally cleaned with receipts provided. So the first part says that it needs to be cleaned and only the carpets need to be professionally shampooed. But if you check that box there, it says the entire property needs to be professionally cleaned with receipts provided. So from a seller's perspective, normally I would read this to them and say, this is what you need to do to clean the house per the contract. So if we check off on cleaning or if the buyer requests cleaning, this is what you're obligated to do. Professionally shampoo the carpets. Then I'll go on to say, well, are you going to do it? If not, then we hire for that and we can check that box. And I normally say that if the home is done professionally and you have a receipt for that, typically that's enough to satisfy the buyer. It's when you don't have it professionally clean that, the buyer could nitpick. So, just be aware, right? If they have the receipts, one is if it's not cleaned properly, you can probably go back to the cleaner or to the seller. And if you're representing the seller, that's one way to make sure you kind of ease any potential problems. If the seller can afford it, I would recommend they just have it professionally cleaned and just be done with it. Any questions on J9? Okay, J10, pet treatment. So seller shall at seller's expense remove any pets from the property, and after carpets have been professionally shampooed pursuant to J9, which is cleaning, have the interior of the property treated for fleas and ticks by a licensed pest control operator. If seller does not have the property treated for fleas, ticks by a licensed pest control operator, as required, the seller shall agree that an amount equal to 150% of the estimated cost of treating the property for fleas, ticks by a licensed pest control operator shall be held in escrow until completed. Provided, however, that any remaining funds held shall be automatically dispersed to buyer by escrow if the property is not treated for flea ticks by a licensed pest control operator within X days after closing. All licensed pest control operator treatment shall be paid through escrow, and any balance remaining after completion of professional treatment shall be returned to seller. Okay, so basically it's saying if that box is checked after you've professionally shampooed the carpets, you have the property, interior of the property treated. So, you could have fleas and ticks outdoors. So I have seen where a buyer would say it'd be great if you guys could also treat the outside. And in some cases it might be better to just suck it up and do that if it doesn't cost too much more, because you don't want a problem later. Yeah, I think that's about it for the pet treatment. Any questions there? Okay, so let's wrap up now. I do need to head out. So I have about 5 more minutes. Any general questions that you guys may have on any of the sections we've covered so far?
I have one about the septic tank that you mentioned.
Yeah.
When you're listing and there's a septic tank in a dwelling, then you have to enclose as one like half bathroom, and you need to describe what it is, or like
I think on the disclosure,
yeah,
there is a box that you check to disclose that there's a septic tank or a cesspool.
I see.
But it wouldn't hurt to include that as part of your listing on MLS.
Okay.
Hey, the question I have is, does everybody really understand what the difference is between a septic tank, a cesspool, and being hooked up to sewer? Now would be the time to, if you don't know.
Okay. Yes, please. Could you explain the difference, please?
Okay, so when you're hooked up to city sewer, everything that goes from your drainage pipes hooks into a pipe in the street called a sewer lateral. And that flows into the waste, whatever the waste departure program is for your city, county, or state, usually a city or county. If you have a septic tank, then you're typically self-contained on your own property. But you can have septic tanks that are shared in small developments in other parts. I don't think it's being done here. But basically, everything that flows from your toilets and your drains goes into a holding tank and uses, I believe it's anaerobic methods to break down waste. And the water that floats to the top that doesn't contain solid waste floats off into what's called a leach field. And there are a series of perforated pipes that lie within an encasement of gravel. And that cleansed water, so to speak, because of the bacteria eating up the waste and the debris settling to the bottom, then flows out into the dirt, the rocks, here beyond on your lot. So if a leach field backs up, then the water doesn't evaporate or doesn't leave the tank, and that's what then flows back into the house, or pops the lid up on the septic tank. So that's why I was talking earlier by septic tank sizes, which I think they're 1,000 gallon, 1,100 gallon, and 1,200 gallon. I mean, you think there's bigger, but I think there's 3 sizes of tanks. They don't get huge.
I've only seen a cesspool. I haven't seen septic tank.
Yeah, there's quite a few of them out like along the water, and the one I dealt with was the water in Makaha.
Oh, really?
Cesspools basically, it's a hole in the middle of the ground. It's usually circular and has a bunch of tiles around the outside, like almost like the ones you use to hold back dirt in landscaping. And the waste just flows into that, and it gets a solid mass at the bottom, and all the liquid just kind of filters through, I believe, and flows through. I'm less familiar with those, but flows into the ground. So those will have to be, and you're either abandoning them or removing them when you have to be replaced. But in the state of Hawaii, they will all need to be removed by a certain date. And it's easy to look it up. I forget what it is too. I want to say it's 2000. I want to say it's 2040. And there is a list of them by TMK number as well, if there's been exemptions given on certain ones.
Yeah.
Does that help you now understand what a septic tank does? It's a waste disposal system.
Thank you.
And you've got to be very careful with septic tanks because you can't be pouring things like, you got to be careful like what soaps, what oils, anything that disrupts, creates an anaerobic upset can cause it from working. So from time to time, you have to have a septic tank company come out and pump out the solids so that there's room in the tank. And if there's ever pollutants that get into the tank that cause the bacteria from working, then they need to pump the whole tank and service it. And you'll see these, you'll hear people talk about selling these boxes of stuff you pour down your septic tank and certain kinds of paper. You're not supposed to use a lot of toilet paper. You're supposed to cut back on certain things. So I lived in houses with septic tanks growing up, and my dad was always yelling at us for what not to put down the toilet.
Thank you, Lisa.
You're welcome.
Okay, any other questions?
I have an interesting one, and Lisa, maybe you can help me to refresh my memory. Remember the property that we talked about up in Tantalus, and it had 2 septic tanks, and there was was there 1 septic tank, but there's supposed to be 2 septic tanks if there's an ADU. There's supposed to be a separate septic tank if there's an ADU. So I just wanted to bring that up because I ran into that, and it was going to be a showstopper. So we didn't even make an offer on the property. But if I think I just wanted to bring that to the table in case anybody else seems to run into that in the future. It was something I didn't know about until the lender said, oh, no. So I don't know if anybody else has dealt with that, but
Yeah, we talked
that's
about
something
it
that came up
earlier in the
on
meeting, I think before you jumped on, we talked about this, is that it's bedrooms and baths and square footage. And I'm not sure if it's the ADU or if it has to do with combined bedrooms and baths. So when you go past, I think it's when you go past 5 bedrooms, it has to be, if my memory is correct, once it goes past 5 bedrooms, you need 2 septic tanks. So it has to do with the number of people they believe will be living in the structure.
Oh,
And
okay.
and in which case to put 2 septic tanks on the property, I think it was that you had to have, it was 12,000 square feet or larger on the lot. I think the lot in question, the one I have, is like 9,500. So there wasn't the space to put in a second tank. And even because you need leach fields for both of them. Or at least one large one that they can flow into.
So interesting. And then there's the permitting issue if you're going to add one, is that right?
Yeah. Has to be through, I think, DOH too. I think Department of Health has to approve it. The contractor has to file for a certificate. Not only the permit, but they have to file for a certificate. I think it's DOH. You're stretching my memory, Lorinda. This was like a year and a half ago.
Sorry, no, you're doing great. And I am so grateful to know any insights about this because it was totally foreign to me.
I've got a guy that was referred to me and I can't remember. Barry Wong, who owns an inspection company, gave me his guy. And this guy was great because I just got all kinds of information from him. He knew the neighborhood. He said, yeah, this is how much it'll cost me to put a tank in. Definitely, the soils are potable enough that it's not a problem. So having good people that you can pop into your command database as service providers and reach out to for answers, definitely start building it. When you don't know, when you just start asking around.
Awesome, thanks.
Okay, great, guys. I gotta take off, but thanks again for today. Then we're gonna start up again next week, Thursday, right? Continuation.
You are such a blessing, sir. Can't thank you very much. Everybody
you're
give
welcome.
a little air applaud. We're so blessed to have him.
Thank you.
You're welcome.
Thank you
You guys
so
all
much.
have a great week.
Bring a
Thank
friend
you.
next week. Everybody should be on
Bye-bye.
this. Bye.